And hello, everyone, and welcome to the Copyright 2.0 show, episode number 362. I had to think about that a second. My name is Jonathan Bailey, as you can see below. I am from the site Plagiarism Today, which can be found at plagiarismtoday.com. And joining me is not only an attorney, but a man who is guaranteed to make you absolutely jealous when he tells you where he's been during our hiatus, Evan Sherez. Evan, how are you doing?
I'm doing well, John. How you doing?
Doing fine, doing fine. So go ahead, get it over with, make everyone hate you. Just get it over with.
I was in Mexico for a week, and then I was in Montreal for 2.
See, already I hate you more. I'm just saying, that's all I needed to hear. You know, you never left North America, though. You never left North America. It's very important for absolutely no reason.
Actually, it actually is important. I mean, not that important, but when I ended up going back to Canada and then through to Mexico, I had to pass the border again.
Yeah.
And they look and they see I'm Canadian, obviously, so I have a work visa. And when they were asking me where I've been, the border officer told me, "Oh, we don't have to like reevaluate the visa because you stayed in North America." So apparently,
Really?
if I had left North America and come back, they'd have to do some paperwork, but no paperwork for me, and I got through in time.
Like England or something. It'd been different. Wow, that's bizarre.
I agree. But
you know, every time I learn something new about immigrations and border enforcement, the word I usually describe it with is weird. Actually, that's the most common word.
Yeah, it is a bit of a funny system. Some say broken. But yeah, I had a great time in Mexico. My brother is getting married, so we did a bachelor party. It's awesome. And we bought them Speedos and funny shirts, and obviously humiliated them because that's the rite of passage when it comes to a bachelor party and getting married. So we did a great job humiliating them. And in Montreal, I got the chance to relax. I did a lot of work as well, but I also got the chance to relax in Montreal, which is my hometown, and eat all the food that everyone always misses when they leave their hometown. And now I'm back, and I'm ready to talk copyright.
Yeah, well, I've got a confession to make. I've never actually been to a bachelor party. Wow. It's not lack of friends, not lack of parties. Just I've never been to a bachelor party. Mostly because none of my friends get married, is what I've learned. Everyone at my age is like, oh, well, my friends are getting married. I'm like, none of mine. I mean, I had a couple get married over the past week due to passing a gay marriage. That had I did.
Congratulations.
I did attend one wedding recently, some friends of mine, and I've got a couple others planned, but other than that, no, my friends just aren't the marrying type, I guess. I just hang around with the wrong crowd.
That's something that we didn't really get the chance to talk about because I was out of town for some of the most significant decisions of the decade. The Healthcare Act was held up again, and you also had, obviously, gay marriage bans determined to be unconstitutional. So we didn't get the chance to talk about that. And even though it didn't really touch on copyright, I feel like anyone talking about the law would at least, mention how there's a historic ruling.
Well, I'll say this about the just to keep it purely on the legal side right now. I found it very interesting with the gay marriage ban how the trickle effect happened with it, because it wasn't like, okay, it happened, everyone run to the courthouse now and get married in like 5 minutes. That's not how it worked. It had to trickle its way back down a little bit. Right.
There were some procedural issues because once the Supreme Court made its decision, other bans across the states weren't automatically voided. There was some procedure when it came to voiding them and then instructing their clerks to then comply, and some states moved faster than others. Mm-hmm. Others, even though they had a ban, got instructions from their governors to say, okay, issue the licenses, even though the process isn't going to be immediate. And then others, I believe, for political reasons, said, oh, we just have to go through the process first in some sort of effort to appeal to their base. Yeah. Which, of course, we try not to get political on this show, but I don't mind saying that that's ridiculous. And I'm very happy to.
We don't get political, but I'm totally in your camp in this one.
Yeah.
And the other thing about it I found very interesting that I learned in all this was that Orleans Parish, where the city of New Orleans lies, basically, here in Louisiana. I did not know this, but our marriage licenses come directly from the state. We do not have a parish clerk of court issues marriage licenses.
Okay.
So we had to wait for the actual state of Louisiana, aka our very, very Republican governor and presidential candidate right now, Bobby Jindal, to allow gay marriage in one of the most gay-friendly cities in the country, basically.
Wow.
That's kind of weird, kind of awkward, but I did get to attend one very lovely ceremony here. Got a couple others seem to be happening. My girlfriend Crystal is a photographer, and she's excited about this as far as job opportunities. And so, yeah, it's been a very good thing for us. But, yeah, I realized this last week that the first wedding I'd been to in probably 5 years was a gay wedding. So,
well, there you go. Gay marriage is good for the economy. You heard it here first. So let's dive into copyright. Why don't you tell our listeners what we're going to be talking about today?
Well, today we got a laundry list of stuff. We were on hiatus while you were doing your travels. But we're starting off with something they handed down just today, because I'm going to start off with something fresh, and that's the Blurred Lines update. And this is a very significant update, I would say. We also have Google being denied by the Supreme Court in its ongoing Oracle Java dispute. Almost unbeknownst to me, it appears the Dancing Baby lawsuit is still a thing, and there was an appeal heard on it. That surprised me as much as many other people. The Turtles are now making moves against the RIAA and their ongoing case against Sirius XM. We have an update, a very important update in the Jumpman logo lawsuit, not entirely unexpected update after recent developments. Monster Energy drink is being told it has to pay at least a good chunk of the Beastie Boys legal fees. Frozen, we have Frozen. We're not going to let it go. We also have an update on the artist wars against Spotify. And finally, wrapping it all up, Google in Canada, a very interesting defeat with possible global implications. So, very, very interesting time. We've got a lot to go through.
Very quickly, I would probably characterize the Frozen story as they will let it go, because
they will. It was a settlement. They did let it go. Good point. Good point.
Okay, so let's jump into Blurred Lines. Tons to talk about here, and I feel like we might be on this issue for a little while.
Yeah, that's fine.
Even then, we're going to be getting a lot out. So, big headline, $2 million reduction in the award given to the gay family. However, they were granted a 50% royalty moving forward, which is good news, because we don't want to get into a place where damages start to accrue again because there's no royalty in place. So we need either an injunction or another lawsuit. So I think royalties are good, because this way the song can move forward. This comes after the judge ruled that the damages awarded were excessive.
Yeah, and they were. I mean, if we'll recall, basically the gay estate made some allegations saying, "Hey, this song you got, Blurred Lines, it sounds a little familiar to us. Sounds a lot like Got to Give It Up by Our Father." And that prompted Thicke and Williams to actually proactively sue, a decision I wonder if they are starting to regret a little bit now, actually. And then it went before a jury, and the jury awarded $7.4 million in damages and miscellanea to the gay estate. And immediately after that, there was a flurry of activities and motions, and now that's what we're getting our answer to, is to that chaos post-trial.
Right. So a few other issues that we discussed last week were also addressed. The court looked at the other parties down the distribution chain, TI, some of the record labels, who the jury did not find liable despite finding substantial similarity, and said, hey, this doesn't really make sense. And they there were two arguments. One was that, hey, these people are in the distribution chain of something that you found to be a copyright infringement, therefore, as a matter of law, they're guilty of copyright. It's illogical any other way. And then those parties who were not found to be liable came back and said, hey, we've got a Seventh Amendment right to a jury trial, and we had a jury trial, and the jury said that we're not liable, so therefore we can't be held liable. So it was almost this catch-22. The judge ended up doing what is, in my opinion, the smart thing, and resorted to sort of a logical fundamental, which is, hey, if a jury found that this song is substantially similar, then the natural consequences of that ruling should trigger, which is that the other people in the distribution chain should be held liable for their parts, at least when it comes to the artists.
Agreed. Yeah, makes a lot more sense. And it was really interesting when this broke because you could tell sort of whose side various authors were on by the headlines, or at least who the headline authors were on the side of. Half of them said, like, we're linking to Reuters now, where it says judge cut 7.4 million blurred lines copyright award, and it goes on from there. But some of them were new trial denied and blurred lines case, or something like.
Well,
really, at both sides, won some and lost some.
That's right, and headlines. I have a beef with headlines. I'll get into when we get into a few other cases, especially when they use terms of art. But I also find that interesting. You could always tell kind of what side they're on, or maybe that's not it. Maybe they just,
or maybe it's
choosing a headline that
they think will get the most interest.
Exactly. I think that's probably more accurate. So I think I wanted to talk about two different parts of this case. One of them was one of the claimed erroneous jury instructions, which is basically the part of the case where you're going to tell the jury, okay, the law says this, you need to find either A or B given this standard. And this is always a very contentious issue when it comes to trial, because the way a jury instruction is worded can affect what they're going to say. And there's so many jury instructions in a complex case because there's complex issues. So
and a good example of how this could be in a different type of case is if you had like a murder trial, for example, you have to find that the defendant shot the victim. It's very different from you have to find that the defendant shot the victim and believed he intended to kill him and believed he was not in fear of his own life at the time.
Exactly.
Two very different sets of instructions with two very different likely outcomes.
The instructions tend to, of course, have a huge influence on the jury, and it lets them know what the law is very succinctly. So one of the main issues in this part of the case, right, this post-trial motion period, was asking for a new trial on behalf of the, let's say, the plaintiffs, because they, of course, filed a declaratory judgment, even though they were the defendants in the more traditional sense of they were the ones who were potentially infringing. Of course, I'm talking about Fick, etc. So they filed this motion, and the standard for a motion is if the verdict is contrary to the clear weight of the evidence, or is based upon evidence which is false, or in the sound discretion of the trial court, a miscarriage of justice took place. So one of the grounds was the thick side of the lawsuit believed that there were several erroneous jury instructions, and I've really only taken one because there were several, and spoiler alert, no new trial is happening, so they lost on every count. So here's one of them.
Oh no, I had no idea how it ended. Oh no.
So this number should be surprising to most listener, but the Fick team felt that jury instruction number 43, which is not the last one.
No.
So that gives you an idea as to how many there are and how
you thought IKEA furniture was tough for the instructions.
So this instruction was telling juries about substantial similarity. Not the only one, but one of them on how to determine substantial similarity in that particular circuit, which of course is one of the elements of copyright infringement, is that in the piece which is in contention, which is blurred lines, has to be substantially similar to the piece owned by the gay family. And so they believe that informed the jury incorrectly. So what this dealt with was the intrinsic and the extrinsic parts of substantial similarity. Now, in this circuit, in order for a piece to be substantially similar, it has to be both intrinsically similar and extrinsically similar. Now, bear with me. I'm going to read you the standards. And then it's only about 2 paragraphs. And I'll try to skip some of the less essential parts.
Okay.
So, extrinsic similarity is shown when 2 works have a similarity of ideas and expression when measured by their external and objective criteria. So to make that determination, you have to consider the elements of each of the works and decide if they're similar. This is not the same as identical, but there has to be testimony and evidence presented that, you know, this theme and that theme are similar mathematically. They're similar from kind of that mathematical point of view of math. You know, they don't have to show that they're exactly the same, but they have to show that the individual elements are substantially similar, and that basically from an objective point of view, these two are similar. Next, intrinsic, is that you have to show that if an ordinary reasonable listener would just listen to the two pieces, they would find that, yeah, these are really substantially similar. So one is more of like the objective mathematical part of music where notes are compared, and the other one is just that if you're listening to it, you know, does it feel substantially similar? So what's missing from this? And this is what the thick camp was arguing, is that they didn't add a very important caveat to that instruction. And that is that when you're making the comparison, you're only supposed to use the copyrightable elements of the song as the basis for the comparison. So they felt like not adding that little caveat, quote, invited a freewheeling assessment of similarity based on any and all elements of the gaze work as a whole. This alludes to this important part that, you know, certain parts of your song are just not protectable. When you're tallying up what's similar and what's not, you can't say, oh, well, they both use a bass guitar. That's not, that doesn't count. You have to take the sufficiently creative parts of the song.
You mean I can't get a copyright protection on bass guitar music?
No, exactly.
And absolutely shut down every bass guitarist in the world.
So you generally have to look at that, at their more creative parts and protectable parts, and compare them. And so they're like, hey, you know, jury instruction number 43 didn't have this. So you basically gave them an avenue to look at everything together, because this instruction said that if you find that they're both extrinsically and intrinsically similar on these two grounds, liability. And so the judge kind of comes back and says, like, I don't buy this. And here's why. Look at instruction number 30, in which I expressly said, quote, substantial similarity requires similarity of protected expression. Similarity that is confined to ideas and general concepts is not infringing. So he's like, hey, I'm not stupid. I know that I gave a whole bunch of them. And
I gave more than 43 of them, in fact.
I gave more than 43 of them, and you can't just take these in the abstract. And he ended up looking at a number of other ones. Instructions 25 and 26 also said that. And Thick tried to argue that these were, quote, passing references to general principles buried within introductory instructions, but that was thrown out, and you know, I agree with that, because the last thing you want to do is try to pull the wool over a judge's eyes, because they know what they wrote, and I don't think that this was going to work, and it obviously didn't. And so that's for example, one of the allegedly erroneous jury instructions that was thrown out.
And you know, if you ever wanted to have pity for a juror in a copyright infringement trial, if you don't have it now, I cannot help you. I have been studying copyright for 15 years now. I find that to be about as obtuse as anything I have ever read on the subject.
Right. If anyone wants to actually read it, because it can be so hard to grasp complex concepts at a paragraph level just listening to somebody. I know that I'm a visual learner. It's on Scribe. It's at page 19. And we'll try to leave a comment to this decision in the YouTube link. Can we go ahead and do that, John? That way people can go and...
I'll get that done. Yeah, I'll find it in the Scribe account and see if I can throw it up there. But yeah, I glanced at the jury instructions too, and immediately got on my hands and knees and was thankful I sat on a murder trial, not a copyright trial.
Yeah, this isn't even that complex litigation. I mean, copyright is decently complex, but it's it's not mergers and acquisitions litigation, et cetera, et cetera. And, you know, to put things in perspective, this was a 56-page complex decision, and the trial ended already. This is just the did we do anything wrong part of the trial. So
yeah, Did anything hopelessly break during the trial process? No? Okay.
So,
Yeah.
next is the remittiture part of the trial, which is the fancy term for the $2 million reduction in damages. And I'll explain that to the listeners if you'd allow me, even though I know that I've been talking for most of the podcast. I promise I'll give you
It's okay. I'll get my time later. Don't worry about it. I'm just making my jokes as we go here. This is great.
The standard for the reduction in damages is pretty simple. If the amount of damages is excessive, it is the trial judge's duty to reduce that or to give a new trial.
Yeah. And we saw this actually repeatedly in the Jamie Thomas case.
Mm-hmm.
So on 3 different occasions in the Jamie Thomas case, which is insane. But okay.
So I learned something, which is that how does the new trial come up? And that is if the prevailing party, which in this case would be Gay's family, does not accept the reduction, then a new trial is ordered. So I thought that was an interesting.
But sometimes the new trial is only on damages. They maintain the verdict of liability, but have a new trial on damages only.
Absolutely, that's a fabulous point, John.
Yeah.
So here's how damages were calculated. And
on the back of an envelope.
Pretty sure I have this. Bear with me. So there was $16.6 million in total revenue.
Okay.
They reported.
Wait a minute! Whoa! It made $16.6 million in total revenue.
That was for all of the different parties. Yes.
Hmm.
Is that more or less than you thought?
I'm actually just a little bit less, honestly. That song was every goddamn where for a while there.
Maybe that's only publishing revenues. I don't know if they took into account all other. I mean, it should be all other, but
yeah,
I mean,
I don't know. Like, do you take into consideration T-shirt sales, which inevitably happened? You know, things like that. I don't know.
I don't think so.
I don't think so either. But still, no. It's just interesting that that's the much they made. So that's the amount they made off the recorded track, and I would also assume the actual composition.
Well, this is broken down. In the decision, $16.6 million, I believe, covers for more parties than just Thicke and Pharrell. $16.6 million was the publishing revenues, I believe, for a number of different parties, about 5 or 6 of these record labels included. But nonetheless, that.
Oh, that's right. This trial only covered the composition because remember, the Gay estate can only bring the composition in.
That's right. Not
so yeah, okay. That's why the number isn't where I thought it would be. All right, there you go. Mystery solved. Please continue.
So, what was reported for Thicke and Pharrell was that they made $6.3 million in total revenues for that. That's what they came up with. That was their stipulation. 6.3. Sorry, for Thicke, Pharrell, and Harris. Thicke and Pharrell were found liable, and Harris was not.
Even though he was listed as a songwriter.
Right. And 5.6 million of that was Thicke and Pharrell, who were the only 2 found liable. So the plaintiffs claim, the Gay estate claimed that this number wasn't accurate, and this is before. This is not in the. I apologize for not making this clear. This is during trial. This is in the 2 stipulations. They're like, hey, that's not the right number. The right number is actually $8 million because professional fees were subtracted to the revenue, making it lower than it is. So that would be the money you're paying your accountant and this guy before you actually get the money in.
And all the middlemen handling the license interchanges and all that stuff.
I don't know if all expenses, which would include those parties you're mentioning, are included. These are the off-the-top expenses that you're paying like percentage commissions to.
So basically, we're looking at revenue versus profit, sort of.
No, it's not that. It's revenue. Revenue minus certain percentage-based expenses.
Okay.
And not all expenses. So it's not exactly pure profit. It's just certain expenses are calculated into the revenue rather than not. And that's just a question of what kind of deals you're making with people who you're doing business with. So the judge actually ended up here admitting to making an error in instructing the jury to use that $8 million figure as basis of damages. Because as it turns out, that pre-expense deduction for the accountants, etc., could only be used as the number if willful infringement was found, and that wasn't made clear on the jury instruction. And as it turns out, the jury found that the copyright infringement was not willful. So when they looked at the damages, which ended up being calculated at $4 million for Pharrell and Thicke, which is clearly 50% of the $8 million, which is the number they ended up giving. They ended up giving 50%. They're like, okay, clearly you used this $8 million value, which you really couldn't use as your basis. And so what we're going to do is we're going to do two things. First thing is that we're going to use this revenue number after the accountants were paid and not the pure revenue number. We're going to bring that down. Then what we're going to do is that since we found that as a matter of law, Harris, the third guy, who they found not to be violating the jury, but the judge then says, hey, if this is a copyrightable, if this is copyright infringement, then you are guilty as a matter of law. They put his revenues back in, which came to a total of about $6.3 million. So now you're taking the revenues of all three writers, and they took 50% of that, and that turned out to be $3.1 million, and that, ladies and gentlemen, is the end of the story.
That's very interesting.
Isn't it? Or did I just bore the hell out of everyone?
No. Actually, it is, because you can see how they kept the spirit of the jury decision intact, if you will, the intent of the jury, but better aligned it with the facts of the law.
Exactly.
And for the mistake the judge made in the instructions, because the jury made it very clear. We think this percentage is fair, and then basically,
right. That's right, and they use that percentage as a royalty.
Extrapolate out a little bit of algebra going on, but nothing too serious. and you can also see how that same percentage comes back up in the royalties.
That's right. They obviously thought it was fair.
He obviously did not disagree with that. So 50% is the magic number in this case.
That's right, and more math than you ever thought you'd have
50%
to do on the Copyright 2.0 show.
Yeah, exactly. Yeah, we don't math particularly well here. But yeah, so it's obvious that he felt the jury was not out of line with the percentage. Like I said, just made an error in the jury instruction regarding how to calculate where the sort of the starting point for that, and ran from it there. Now, it's like I said, this is such an interesting and complex decision because both sides won something, both sides lost something. You know, Robin Thicke and company, they won the reduction in damages, and they also at least got the judge to admit that parts of the instructions had issues. Not enough necessarily to, sink the whole trial, but enough to, lay some groundwork for a possible appeal.
Right.
On the flip side,
as you mentioned, if there was a big error based on damages, that could be a relitigation of damages. But
not only liability.
4-page decision, and I've omitted several, if not a dozen, new trial grounds that the Pharrell side was trying to push that was rejected. Yeah.
And on the Thicke side, and on the Gay Estate side, they obviously won the retrial issue pretty handily, it seems, and they also won the right to involve more parties in the infringement. So get more parties liable for the infringement. Those are two things they were seeking, but they failed to get the injunction that they were seeking.
Right.
However, I don't think either side's going to be happy about the royalty structure necessarily, because
I don't think the injunction was what they really wanted. They wanted the bargaining position.
A little bit, but I think they were really hoping to bring the hammer down in negotiations.
Yeah, an injunction would have been a massive
tool, and they didn't get it. So it's a win some, lose some for both sides, and I think what this really does is set the stage up for an appeal, which I expect to be filed by the time this podcast is over, pretty much at this point. I think we'll be doing an update within the hour, at least it'll feel that way. But yeah, I fully expect an appeal on this and more to be heard from this case. But what's very interesting, and what I think this highlights, is everyone's been talking about how we're living in dark times for creativity, and the Blurred Lines case is destroying, the ability to be inspired by music. And I think what this highlights is just how much of a perfect storm this case really was in some ways. It really, I don't think we're ever going to see one like this again. I would be stunned if we did.
I mean, what is like this is just such a unique case.
It is.
And that I agree with you. We won't see anything quite like this.
And it's made worse by all the ways in which Robin Thicke himself, and I guess Pharrell Williams too, sabotage their own case along the way.
See, that's what I don't like about this from a policy perspective, is that artists will be more hesitant to pay homage and give credit where credit is due when it comes to their inspirations and their musical heroes for fear of this, and I hope that doesn't happen.
Well, and it's bizarre to me to think about this in the light of like the Richard Prince and the Richard Prince ruling recently, which ruled his artwork to be a fair use when pretty much using photographs taken by other people and just drawing on them. You sometimes feel like there's a lot of chaos in this area of what is a derivative work and what is a fair use, and what, I mean, this whole area seems to be constantly in flux. And I don't think this one case necessarily is an earthquake by itself. It's just another, sort of pin on the board, so to speak.
Right. This case, as I believe you and I both stated when it came out, was more of an instruction on client management and mistakes that can be made during trial, and just honestly a cool example of how a copyright case operates, rather than any sort of groundbreaking legal concept when it comes to substantial similarity or anything from a legal perspective to be groundbreaking. I think. And
at the end of the day, for me, I don't feel like necessarily Thicke and Williams lost because they had the worst argument. I feel like they just simply got out-litigated.
They got out-litigated, and they got punished for being on pain meds.
Oh.
And then trying. No one likes when you say something. What he should have done was own up to it. Was said, yeah, I said that. I said I was inspired by Marvin Gaye, and you know what? I was inspired by Marvin Gaye, just like dozens, if not hundreds of other artists are inspired by Marvin Gaye. But that doesn't make my song a copy of Marvin Gaye. No. It was inspired, which is allowed. You're allowed to be inspired by another artist.
Yes, absolutely.
But going back on his statement saying I was high on painkillers, that doesn't sit well with juries. They don't want to hear that, A, you have a drug problem, because they're not going to look kindly upon you, and B, they don't want to look at you weaseling out of a previous statement because it makes your testimony less believable, even though the things you may be saying for days and days could be, in the trial, could be extremely valuable to your case. People look back to that time where you kind of weaseled out of something, and no, I don't think that was a good strategy. Obviously, they didn't have a concrete strategy of how to deal with that statement throughout from deposition to trial, because she should have owned up to it and taken an angle of, yes, I was inspired.
I love Marvin Gaye. Who doesn't love
Marvin Gaye? Exactly.
Marvin Gaye's awesome.
Marvin Gaye's amazing.
And he was a great musician. I mean, he's awesome.
Should have taken the high road and be like, I wish his family would, wouldn't. I wish this was a better, but yes, I was inspired by Marvin Gaye, but no, I didn't copy him.
Yeah, I agree with that. Well, you want to move on?
Let's move on. Well, I don't want to move on because I want to skip this next story, but let's do it. Let's get it over with.
I feel the pain on that one, my friend. I feel the pain. Long story short, while the Supreme Court was busy tackling issues like, gay marriage and Affordable Care Act and yada, 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 it also announced it was declining to hear Google's appeal in its case against Oracle. And the long and short of this one is Google, when developing the Android operating system, wanted to make its own implementation of Java, which is owned by Oracle. But rather than licensing it directly from Java, basically rewrote the language, didn't use any of the actual original code, but copied the Java APIs to ensure that any application written in Java for other things would work reasonably well on Android. And for that, Oracle sued, and at the district court level, Google got the court to agree with its argument that APIs, which are basically a set of commands, were not copyrightable. However, when that matter went to the appeals court overturned it. Now, Google appealed the appeal, and the Supreme Court, and this is what the Supreme Court can do. This is why this is the greatest job you can get. went, nah, we don't really feel like taking that one, and let the appeals court ruling stand, basically punting the thing back all the way back to the district court.
Right. So my favorite part of at least reading the story was that how they described APIs, which is obviously impossible for us, as we've failed on many times, was to describe APIs as programs which allow other programs to communicate with each other in an organized fashion. So I think I'm going to stick with that.
Yeah, okay, fair enough.
So as you mentioned, yeah, basically they were initially found not copyrightable due to the use of utilitarian and functional set of symbols. This alludes to the utilitarian concepts in copyright law. So just really briefly, certain things, if they're known as a useful article, is an object that has sort of intrinsic utilitarian function that's not part of its design, and those are basically not eligible for copyright. And so what they were saying is that these particular order or use of these symbols was utilitarian in nature. But that was reversed, as you said, and the denial of certiorari is a huge victory for copyright software, the copyright of software, and software companies and proponents of software. Yeah. So
yeah.
That's all really I have to say about this story.
Yeah,
and it's not really something
the one thing I do want to add to this story, though, is when this happened, everyone ran around like Chicken Little saying the sky is falling, APIs are copyrightable, everyone's going to be suing everybody and all this. And to which I responded saying, if you go back to the district court proceedings, as you would expect, Google put up a variety of defenses as to why it was not an infringement for them to use the APIs. They said it was not copyrightable. They also argued, though, that it was a fair use. And the fair use defense never even got heard because it was completely rendered moot by the idea that APIs were not copyrightable. Never had to touch it, never had to listen to it, never had to hear it, never had to think about it. It just didn't come up. Well, now it's going to come up. And if the use of an API in this context is ruled to be a fair use, then realistically it has almost the exact same function and exact same practical application, because if using an API is not infringing in this case, there's not going to be many cases where it is, you know? This is as far afield as one can typically think of this type of stuff. Literally rewriting an entire language. So, I don't know. I think before we say the sky is falling, we should see what the district court has to say.
Yeah, well, I guess I'll talk to you in
6 years.
Yeah, a few years.
All right, the dancing baby case. It's still a thing.
Still a thing. We have a mother who is videotaping her baby getting down to Prince and dancing, and puts it on YouTube. It gets up to a mind-blowing 233 views, I think the story said, before it is taken down.
273 views.
273 views, excuse me. It should be disbarred. Before it's taken down due to a DMCA takedown notice, which of course is the process in which a copyright owner can ask that any media hosted by a third party that contains the copyrighted material be taken down because, hey, I own that, and this is the mechanism that the DMCA gives them to have these things taken down. So it gets taken down. And what happens next, John?
Well, major headache happens next. Now, Lynn, the mother, her last name is Lenz. Her name is Stephanie Lenz. She files what's known as a counter notice, which is where basically copyright holder files a copyright notice saying, "Hey, that's mine, take it down." And basically, the counter notice is legal for or otherwise it's not infringing. No. And basically got the work restored. Now, the work was restored just fine. No further action was taken by No further action was taken by Universal Music Group in this case, and it seemed like the issue was pretty dead. 99 times out of 999 times out of whatever, this is where it ends. But in this case, the Electronic Frontier Foundation and others got involved on Lenz's behalf and filed a suit against Universal Music, alleging that Universal Music knew that the video was not actually infringing Prince's copyright or the copyrights that they hold, and ordered the takedown anyway, essentially filing a false DMCA takedown notice. And that was 8 years ago.
Yes, so just to clarify, one thing is that when you mentioned that it's the legal way of saying, nuh-uh, what this counter notice basically says is that this is not a copyright infringement. And that could be for a few grounds. One, could just not have any of the person's copyrighted material at all. Or, in this case, they're alleging that, nuh-uh, because even though your material is on it, it's fair use, which is that affirmative defense that we always tend to talk about. So that was this case, is that this is...
Yeah, and this led to a huge back and forth about whether or not copyright holders, when filing DMCA takedown notices, had to weigh fair use and the potential issues. And the judge eventually decided, okay, yes, they do, but to what extent, because fair use is such a funny thing, if you will, and that you and I, and if we get, 3 people in a room, we'll never agree on pizza toppings and what fair use is. So it's like, these are the rules.
Right. Another quick note is that the actual legal basis for the case ends up coming into play as DMCA section 512F, which is that it bans misrepresentation, that material is infringing or removed. So it basically says that if you kind of misrepresent that you own something, and that thing becomes disabled, and it's a case where the material is removed wrongly, you can end up being liable for damages, costs, insurance fees, etc.
Now, and that 512F is interesting because it specifically says the filing has to be in bad faith.
Right.
Makes it very clear this cannot be an accident. If you oopsie and do it, it's no harm, no foul. But if you genuinely, knowingly file a bad DMCA notice, if you lie or misrepresent something knowingly, that's a different issue. And that's the core issue at stake right now. Was, did Universal knowingly misrepresent something or mislead something here? And it seems like the EFF and others are having a tough time convincing the courts they did.
Oh, it's not only there is another way to get there, right? It's not only knowingly, but also there's also the issue of willful blindness.
Yeah, willful blindness. Yeah, I forgot.
So
about
that's the real angle that they have. I don't think they're going to be able to show that there was an intent to take it
Let's
down.
screw the mom and her baby.
Exactly. Let's take down this 20-second video because we have some sort of malicious intent. But if there's a willful blindness to fair use, that's an avenue open to the EFF by the district court, which basically said that, we're going to let you go to trial here, but you're going to have to show that there was willful blindness, and that particular decision to allow them to go to trial is what is being appealed. And so, the EFF thinks that you should have to pay damages for a wrongful takedown notice because you didn't consider fair use and you did it either intentionally or willfully blindly. And Universal is saying, listen, the takedown system just cannot function if there are financial penalties for this type of wrongful takedown. It's meant to help companies with infringement en masse. And,
mistakes happen.
This mistakes happen, and there's nothing in the statute that says we can't do this. And at the same time, even if also another point is that they also weren't conceding the fair use point.
No.
Which saying it would be a contentious issue at trial, which is ridiculous. No one is going to find a mother at a 22-second or however long it was. Actually, not sure how long it was, but I know it was short. No one would find this woman liable for a lack of fair use for putting a YouTube video of her dancing to a Prince song.
In the background, barely audible. I'm amazed whatever software they had detected it. I mean, that's some damn good software. I'm just saying that.
I guess it's just sound legal.
Fun.
It's sound litigation technique. Not technique. What's the word I'm looking for? Sound legal philosophy or
Yeah.
procedure to just never concede anything.
Yeah, and that's you never concede anything ever, realistically, even on this. As he's being a good lawyer by doing that, basically. He's doing the right thing, but still, yeah, I agree with you completely. That's completely and utterly insane to say that this is not a fair use. You know, it's crazy to me. But that's the argument they're going with. Now, the thing that's interesting is I remember a while back when this case started, the courts had ruled that if Lens is eligible for damages, those damages are effectively nothing because this caused no real harm or disruption in her life. And this would they'd be limited. I believe the court said that they'd be limited basically to her actual damages and not legal fees. So if she were not being supported by the EFF and others in this, there's no way this would be a practical litigation for her. You know what I mean?
Right, you have to have damages, and
you have to have the damages. So even if Universal ends up losing, they could end up winning if the damages are so insignificant that such litigation is completely impossible or impractical in the future.
Right. You know, I did take a class in law school where we would look at famous Supreme Court decisions, and these decisions mostly had very profound national impact. But then when you kind of did a behind-the-scenes look at the parties, which is what this class was all about, kind of behind the scenes, the actual parties didn't have that much at stake. So sometimes these cases come along where, although these parties have some sort of nominal damages at stake, because otherwise you just can't have a lawsuit, there has to be something at stake. Sometimes you look at these cases and the real driving forces are these, you know, national clash of philosophies where you have, you know, an EFF and Universal litigating what could essentially be future damages or potential liability issues, because, you know, the EFF
they're not thinking about the case at hand, they're thinking about the class behind them, so to speak.
Right. Not only the class behind them, but the Universal is thinking about the inability to send out DMCA takedown notices en masse, because if they'd have to completely rework their system if they were potentially opening themselves up to liability every time they did it incorrectly. So that's what's at stake here, and this is another one of those cases where there's a mom and her baby, and that might be the named litigant, but really the driving force is the EFF and a national philosophy and a national legal battle, you know, playing out through these small ponds.
I agree. Gonna move on to the Turtles. To the Turtles. Well, this case has gotten very, very interesting for me. We've talked a lot about the Turtles lately, specifically Flo and Eddie of the Turtles. They are they're I guess the surviving members. They own the rights to the music of the band, including their iconic song from the movie Ernest Goes to Camp, "Happy Together." I'm sure that was the first time that song was ever aired.
It's actually my family's song. It's like it's a Sheriff's. That's every single time my family gets together, that's the song that they all sing.
That is surprising. That's incredibly cool and touching. But yet, all I can think of when I hear the song is Ernest Goes to Camp. I'm not kidding. That's like my only memory of the song. So it's just amazing how different our histories of this song are. Oh man! But they have been locked in litigation with Sirius XM because I think all of the Turtles music was pre-1972. So the sound recordings were not protected under any federal copyright. Why? Because even back when Congress did the original Copyright Acts in 1909, they were still kicking
not the original. There was one in like the 1700s, so the second one.
No, the second. Oh yeah, the first one of the previous 150 years.
Fair enough.
But yeah, they like to kick the can down the road and make sure that any new technologies like sound recording kind of got a little bit of a roughshod treatment. And they eventually did get around to federalizing it, like I said, in 1972, only after the Beatles, Elvis, the recording music industry blew up a huge thing. Really on the ball. But anyways, so basically, though, the use of sound recordings, pre-1972 sound recordings, falls under state laws. And Sirius XM had been sued by the Turtles in 3 different states, California, New York, and Florida, alleging that they were just not paying royalties, and that was a violation of the state laws, not, like I said, the federal law. Well, they've actually been having some pretty good success with it.
Ching.
They've been racking up some court wins here. Every time we hear about Sirius getting one, we're like, yay! It's like a football game where the losing team finally scores a touchdown. It's like, oh, good, they made the end zone.
So yeah, they've been having all this success, and
then the
all of a sudden, well, not all of a sudden, because obviously the record companies who we're going to talk about here have a stake in this outcome as well. If you think who has sound recordings that are pre-72, who has ownership in those things, well, obviously the record labels have.
Universal, Sony, Warner.
Tons of sound recordings, and you'd think, and I think the Turtles thought this as well, is that both were on the same side here. They both want the same point of law to come through, which is that this California state law protected their sound recordings, which is going to entitle them to damages. So hey, we're on the same side, and then
and it's added legal pressure on Sirius at this point. This is great.
And then I think the term "friendly fire" is a bit of an understatement. This was like a friendly nuke. This is like a 1984 situation where all of a sudden we're at war with a different continent.
Yeah, and basically what happens is the RIAA, the record labels, swoop in and actually reach a settlement with Sirius.
Right.
That kind of caught everyone off guard.
So it's a complicated.
Go ahead. Yeah.
Here, and I'm not sure I entirely grasp it, but
I don't think anyone does. I don't think you're alone. But
sorry, go ahead.
But basically, they swooped in, they scored the settlement, and they're seeking dismissal of the case. But meanwhile, Flo and Eddie and the Turtles had just secured class action status in their lawsuit. And so they're thinking, hey, wait a minute, this settlement that you guys are reaching in a completely unrelated case could interfere with our class action suit and our class's ability to gain, the damages it's owed. Right. So that's where we're hitting it off here is basically now the Turtles are having to make moves against the record labels for sort of interfering in their hard-fought and hard-earned class action lawsuit against Sirius.
Yeah, so I think where I was confused and where I imagine most listeners would be confused is that, what do you mean swoop in? You have to have an interest in the outcome, right? How could one person's lawsuit affect another one's? And it comes down to this class certification, right? Because the Turtles can go to a judge and be like, hey, there's this issue, and each person who was affected by this issue may only have a few dollars or up to a few $100s or maybe even a few thousands or a few tens of thousands in our case in damages. So what we'd like to do is make a class, which is the basis for class action that I just described when many people all got injured a little bit. So let's make a class here on behalf of anyone with pre-72 sound recordings who never paid money. So, in theory, that's going to include a lot of people who may have their rights tied up with record labels, either divided or maybe those record labels are allowed to represent others on their behalf. Maybe those record labels can represent artists, even though the artists are entitled to their sound recordings.
And this area gets triply confused when you start thinking about copyright termination, but I'm just going to lob that grenade in the room and run away.
So they get this class certified by a judge, which means that there's a certain period where people can essentially opt out of that, but that passes by pretty quick. And the Turtles can then, as the named plaintiff, get money on behalf of all these other people and then send out the money to those people. But at the same time, now the record companies are coming in and saying, oh, we're going to represent a lot of those people because we have the right to do that. And so the Turtles are like, as you said, are like, hey, what the hell? We just had class certified and you're going to settle out of court for a certain amount of money, which, may not end up in the hands of these other artists in the same degree that we were going to do it. It may affect our settlement as well. And so you're going to get into some very complex areas of class action law that
California law too, from the looks of it.
That I just don't know enough about. But I think that the basics of what is about to happen, I think we've adequately explained, and so they're going to try and stop the settlement from happening.
That's what's happening. Is they filed a motion to stop the settlement from being funded, from having Sirius XM pay it and complete the settlement, and It's interesting here, but I love this. The RIAA send out an email. I'll just read the quote here. This is from this article from Reuters. We have great respect for the Turtles and the work they have done to help secure payment for pre-1972 sound recordings. However, their application is without merit and could force the delay of long-awaited payments to artists and labels who created iconic music for generations of fans. So, yeah, it's that's like the quintessential backhanded compliment right there. Hey, thanks. Get away. Get a step aside now.
Right. They have to obviously say something because most lay observers will be like, hey, these people did go to court and they did win and they did do all this stuff for songwriters, and you're going to just, step in now. And so they paid homage to that. And, they probably have a valid point about it taking longer. It may take way longer for the Turtles to get it. But
yeah, and especially
they didn't say anything about the amount and how much songwriters would get, because that complex accounting that record labels can do.
Yeah, we'll be talking more about it in a minute. In a little while. Maybe I should have put that story next. But yeah, it's a mess. Well, speaking of stories that are a mess, the judge dismissed the Jumpman lawsuit.
Okay. So remember earlier when I said that I really hate, I had beef to pick with titles. So I have beef to pick with both titles and I guess subtitles or just terms of art that are used. Because this is the first of two cases we're talking about today where the journalist says that this case has been dismissed. So obviously I have a job to work and I try to prepare for this podcast as much as I can, but the hours in the day are limited. Yeah. So when I read the word dismissed, I assume that this person knows what they're talking about and that the case was dismissed on a motion to dismiss, which is very different for a motion for a summary judgment. A motion to dismiss basically says that, hey, you take everything that guy's saying in his complaint and I'll admit it's all true, he still doesn't have a case. That's a very different story than a summary judgment, which is kind of step 2 in a case. Well, maybe 2 or 3, but step 2, which is that, hey, there's no issue of material fact here, and if you take everything kind of in the light most favorable to the other guy, all the facts that they brought up to back up those claims, they're still not going to win. So even though what they've claimed to have happened would, if all ended up being true, would amount to basically a cause of action, if you have that, then you can survive a motion to dismiss. But if the evidence you end up, purporting to show kind of doesn't really end up backing up what you were saying would basically happen once you got the chance to show some of your evidence, that's more of what happens in a motion for summary judgment. So when I read dismiss, I'll go looking for the complaint and trying to figure out what's legally deficient about the complaint, and then I'll end up 20 minutes later figuring out that, hey, this journalist just doesn't understand the basics of litigation, and I have to go look for a motion for summary judgment. And so that is what happened here.
And I have to say, and it's especially bad in this article, because I had assumed it was a motion to dismiss too, because the very last line of this article is, Mossman, the judge, heard oral arguments May 26 on Nike's motion to dismiss. He actually says the words, motion to dismiss. So just throwing that out there.
Yeah, so
we talked about this, says it.
We talked about this last almost a month ago, last podcast. Yeah. Basically, we were trumped, right? We were not trumped. There's current events. We were stumped because when I was describing about the different ways in which a photograph can be copyrighted, unique in creation, unique in time, and unique in subject, we were like, well, what is the basis for this that would make sense in a lawsuit? And it turns out there really isn't much of a case because the gentleman didn't own a copyright in the pose that was created. And that's what he was trying to allege, is that it was a unique in creation. I put the ball in his left hand, therefore I now own the concept of Jordan dunking with his left hand. That was just thrown out. Like, no, you don't own a valid copyright, and you need a valid copyright to bring this case. So just backtracking for 1 second. this was ended up being a motion to dismiss. There was the next one that we're talking about is the motion for summary judgment.
I took this
opportunity to just kind of get my beef on the table because it.
Okay, well, beef's on the table.
Yeah, for the next, it's for a case two down the road. But
all right, that's fair enough.
Yeah, this was fair enough. So you said you couldn't allege that you own basically a valid copyright.
Yeah, and then basically he had no viable case whatsoever at the end of the day because he didn't hold a valid copyright in the pose because it's kind of hard to hold a valid copyright in a pose, period. And the judge saw through it and dismissed it. It's really that simple. I mean, there's not a whole lot to say.
Yep.
So Monster Energy drink. This is pretty interesting here because we talk a lot about attorney's fees and how they're awarded, and this is a little additional insight in that. As we know, the Beastie Boys sued Monster Energy after 3 of their songs, remixes of 3 of their songs, ended up in a YouTube video / commercial for an extreme sports event Monster was putting on. The Monster admitted to the infringement, basically, but they had a dispute on damages, and the jury ended up awarding $1.7 million. However, the Beastie Boys came forward and said, hey, that's great and all, we appreciate the award, but we actually owe $2.4 million in legal fees, so this kind of sucks.
Right, and what ended up being awarded in legal fees was only a fraction of the $2.4 million that the Beastie Boys spent, and they were awarded about $668,000, and it only ended up coming out ahead by $500,000. So it just crazy how expensive litigation is, and this speaks to that. They only come out ahead $500,000 with you're getting $668 in legal fees.
Yeah.
And what do they get? 1.4 million. How many million did they get in?
1.7 in the initial verdict.
So, the interesting quote in the article you sent was that the judge said that they went for the Cadillac Escalade and not the Honda Civic of legal representation, and that
you're selling Monster Energy. Of course, you're going to get the Cadillac.
Yeah, that's ridiculous. Why can't
going against a major corporation with Johnny Podunk, sole proprietor at large?
I'm hoping that the article just maybe took that out of context, or there were a number of other grounds to reduce it to that number, but I think that's preposterous that a judge can make that sort of call. Yeah, a judge can look to the actual work, of course, that was done and say, okay, maybe half of this wasn't really needed, or maybe a quarter of this wasn't really needed, but to look at the rates chosen,
especially when you're dealing with a high-profile trial like this.
Yeah,
if I were suing, just some random individual, and I came at them with a high-end, you know what I mean?
Yeah,
that'd be one thing.
The only justification for this judge's statement, if this was a significant part of the basis for the significant reduction in damages, is that this was a slam dunk case, right?
Yeah.
This was their song in an unauthorized fashion. There's no substantial similarity issue. You used their song. And so the Beastie Boys knew going into it that, there was a win here. There was no real fair use defense. This was a commercial use of the Beastie Boys song in a commercial endeavor that the Beastie Boys never promote and never would promote. And it wasn't, the Monster had just been in a few wrongful death cases. Like it was a slam dunk. So I imagine, or I can sympathize with that notion that maybe you went with someone extremely expensive just to punish Monster, but I think it's still a bit of a stretch.
And it's a bit of a stretch, Now, one thing that may very well happen, and I obviously cannot speak to the relationship between Beastie Boys and their attorneys, is sometimes there's further adjustments made after these types of rulings to keep, the client from basically losing money or barely scraping by in a case. But that's not always the case. Not every law firm does that. And certainly the larger, more established law firm, the less likely that's going to happen. But still, I have heard of it happening in like auto accident cases and so forth where attorneys will say, okay, if we settle now and I take everything I'm owed, you only get like $1,000. I'm willing to have done all this for a thousand or two less and let you walk away with a more reasonable amount.
That makes sense. And well,
I'm not saying that's going to happen here. I'm saying I've seen it happen. I've actually had it happen to me once. So, so there you go. I actually have an attorney friend of mine who has a rule in all auto accident cases that he will never take home more than his client. So
that's that's nice of him. John,
yeah.
I just have to say something about the story. I think I'm ready to let it go.
Oh, yeah. Well, apparently Disney is too. This next one.
Disney is ready to let it go too.
Yeah, they're really eager to let it go. Apparently, in this one. So yeah, Disney has now settled its ongoing lawsuit over the trailer to one of the I guess we call it teaser trailers for the movie Frozen. And to do this, we have to go back way to the beginning of Frozen, back before it was actually released. And Disney kind of did a teaser trailer that featured Olaf on a frozen lake battling, I think it was a moose in that case, for his nose. And it was hilarious. It was funny. And the only person in the world I don't think it was really funny to was the one particular filmmaker. I'm trying to find her name here. Oh, it was Kelly Wilson was her name. Sorry, I lost it in the article here. Kelly Wilson didn't find it funny because she had a short film called The Snowman, which pretty much was the exact same premise, involving a snowman fighting in that movie with a rabbit on a frozen lake.
Yeah, apparently
the similarities were pretty darn striking. So
yeah, there were. This was actually I believe the dismissal case. They were using languages like they dismissed it, or it was dismissed after.
They said it was dismissed without prejudice because of the settlement. The two sides had requested to be dismissed, which is how that.
I think it also says something about there being deficiencies, and there were two. I believe they'll use the words that Disney failed to dismiss it twice.
Yeah,
and of course, what that maybe looked for deficiencies in the complaint or alleged deficiencies in the complaint. Turns out it was summary judgment, which of course is a much different standard.
Basically they sought dismissal and then a summary judgment and lost both of those. And
exactly, and then they ended up settling.
And then they decided they'd better settle because if this goes to court, it could get ugly very quickly for them. Because I'm not going to speak to whether or not it was actually copyright infringement. The similarities were pretty obvious, and getting something like that in front of a jury, as we've learned in the Blurred Lines case, is super risky. And Disney's smarter than that.
Yeah, especially when you want to produce Frozen 2.
And that's why they did. In fact, that's the little sub-headline on mine is Frozen 2 officially a go. Parents, get in the shelters. Frozen 2 is officially a go. This is like a tornado warning. It's coming. All right. Well, this is a bizarre one here. A new lawsuit against Sony over its deal with Spotify. Now, we'll recall back some time ago when Sony was inking its first deals with Spotify. One of the things it did was it took a small equity stake. I think it was like 5% or something like that. I don't remember. Does it say what percent it was? But it took a 6% stake in the company in exchange for lower rates. Well, artists, in this case, there is apparently a company called 19. It is simply 19. That's the name of the company. The numbers 19. Represents a lot of the American Idol affiliated artists like such as Terry Clarkson and Carrie Underwood are suing, saying that deal was improper because basically it shortchanges artists because, hey, we're not getting our cut of that yummy stake you took in the company. We're only getting our cut of the royalties.
Right, because they negotiated to obviously have those royalties be smaller than they otherwise would have been in a good faith representation of the artist. They're like, hey, let's take equity because we don't share that with our signed artists, and let's take advertising revenue because we don't share that as either. And then the rest of it could be revenues, which unfortunately we have to pay to our artists.
And I've got to say, Sony has not done a lot to endear themselves here. Basically, their counter argument is yes, this is disadvantageous to artists, but yes, we also have the right to do this. So nanny boo boo.
Mm-hmm.
That's basically their entire argument. They're saying that there was nothing improper about the deal. The deal as a whole was fair in their eyes. It's just that the deal as a whole might have been somewhat disadvantageous to the artists, you know. And that's what basically is at issue here: is was Sony negotiating in good faith on behalf of the artists? And I don't know. Like I said, they're not doing a lot to endear themselves with their language here. But
the artists are alleging now they want to make it an issue of, you basically breached good faith and fair dealing promise that you make in most contracts. There are certain things that are implied by law in contracts, even though they're not stated in those contracts. Yeah. And one of those is a duty of good faith and fair dealing in any contract, which is that you kind of have to execute this contract in a way that represents the spirit of it and the spirit of good faith negotiation, because there's lots of different ways that you could take express language and be like, well, I don't actually have to do that. A good example of this principle is like, you sign an exclusive representation argument. You sign an exclusive representation contract to like sell a house. Like, okay, you're the only person who can try to sell my house. I can't even try to sell my house. And then like you don't do anything. You're like, I'm sorry, now you just can't sell your house for a year. Like, well, no, you do actually have a duty to try to do it. Do the thing that you said you would try to do. So
yeah.
They're going to be alleging that the record labels have the duty of there's a certain good faith responsibility to try and make money for themselves and their artists, and not try to structure deals in a way that kind of screws one side of them, which Sony's admitting to doing here. So it's an interesting line.
Yeah, but I think what Sony could counter argue here is that, well, we had to take the deal this way. It was the only way to get a fair compensation and ensure that Spotify could afford to move forward. That Spotify's business model couldn't support higher royalty rates. So if we were going to get anything, we had to do it this way. So I'm sure they're going to have arguments on their side that shows that, yes, it's disadvantageous to the artist, but it was still the best negotiations we could get. But yeah, the way they're putting it right now is not really endearing themselves to anyone. I'm hoping this article, and I know Eric Gardner from the Hollywood Reporter. I don't think he's the type of guy to misrepresent things, but I'm hoping that this is kind of a context issue here too, and that Sony's not.
They're also going to say that look, there's like 100 different factors that come into making these deals, and this was not a deliberate attempt to screw the artists. This is just kind of how the cookie crumbled in terms of this deal that could be made, and that's when we have the right to kind of do that. And not every deal will be perfect for our artists, and
we're just doing the best we can, basically. It's good faith, but good faith doesn't always yield the perfect results.
No. So our last story is the. Did you pick this one because I'm Canadian? Was this a?
Yeah, it's Canadian. Yep.
So.
I didn't realize I picked two Hollywood Reporter stories back. Oh well, but anyways, moving on. The Canadian story. This one is interesting. Google suffered a bit of a setback in Canada, and this has potentially global consequences here. The case was brought about by. Okay, you're Canadian. How the heck do you say that name? Equistec Solutions.
I want to hear you try that a few more times. I have no idea.
I have no idea.
EQUUSTEX. I would say
Equistec. Yeah, I have no idea. Equistec. It sounds like Equistec to me.
Oh, maybe it's supposed to be acoustic, but they just wanted to
that'd be clever. If like a weird spelling of acoustic, that could be it.
I get it. It's acoustic, as in like referencing to music, but EQ, as in that music concept of your EQ, and they're since they're a maker of industrial network interface hardware, maybe they work with EQ, but they work with me. I'm drafting straws here. Anyways, go on.
Yeah, but anyways. They brought a lawsuit basically against a competitor. They allege that was selling in this case, it actually seemed to deal mostly with trademark infringing goods, goods that they claimed were from or acoustic and were not. And the Canadian court agreed and ordered Google to officially stop linking to this site within the google.ca, basically domain, basically their Canadian site. Well, acoustic, I'm running with acoustic. I've decided I like acoustic best. I'm going to run that route. Came back and said, hey, wait a minute, that's actually not particularly helpful because, you know, there's hundreds of other Google sites and, you know, we're not even the biggest one. The Canadian one's not even the biggest one in terms of traffic. So the court agreed and is now ordering Google to basically issuing a worldwide injunction barring Google from linking to it globally, including the United States and elsewhere. It's the first I've heard of such an injunction, a global injunction. And it could obviously have very major impact on copyright because if theoretically, at least, if the court can do it on a trademark issue, other intellectual property issues could use this as well, theoretically. This idea of a global blacklist, if you will, from Google.
Yeah, well, I think this is a pretty big defeat if this does move on.
Yeah, and Google suffered a fair amount of these lately. They also, remember the right to be forgotten recently that took effect.
A lot of responsibility and a lot of hours.
A lot of headache, too, I can imagine, because, you know, you think the DMCA process is difficult. I can't even fathom the idea of having to determine what is private, what is a good, valid reason for removing private information. You know what I mean?
Yeah, you know.
DMCA is basically a sheet of paper with a bunch of links and some sworn statements. You know what I mean? At the end of the day, that's what it is. The right to be forgotten has got to be a much bigger mess. And this is potentially, like I said, I don't want to say devastating, but potentially very impactful to Google because you have a situation here where a Canadian court is arguing that they have the right to order Google to remove links globally. You know,
yeah, that's
pretty potentially huge.
That's. I mean, there's obviously conflict of laws issues. I mean, what if a report says that, you know, we're going to expressly allow this? Yeah, I don't know. There aren't that many courts that would issue a worldwide injunction. I mean, there's like the U.S. Trade court that sometimes tries to flex its muscle beyond its borders, but the internet and injunctions and legal and courts can sometimes mix for some very strange results, especially when it comes to IP rights.
And sometimes you'll have in the U.S. in particular, you have court rulings that have worldwide implications, like when a U.S. court rules that say, you know, the payment processors can't work with a site or a company. Well, Visa, MasterCard, et cetera, are global companies, and they're based here in the United States. That pretty much screws them globally, you know?
Agreed.
So there's stuff like that, but you don't usually hear about these worldwide injunctions. Obviously, a lot of copyright holders are very excited about this possibility. The power. And, you know, so I guess we'll keep an eye on this. I highly suspect there will be an appeal, and this won't be the last we hear of this case, because I don't think Google's going to take this one lying down, so to speak. Maybe they need a Canadian attorney. Do you know any?
I think they need a very talented, young, red-headed attorney living in Washington.
And pay him very, very handsomely?
Very handsomely.
Very handsomely.
Like, incredibly handsomely paid.
I agree. I think that's a great idea. Google, consider that your not legal advice for this day. Well,
so
Evan, huh?
It was good. I think I think this is one of our best podcasts ever.
Yeah, this was good. I think we rolled it through it. It was nice. Well, you want to wrap it up and end on a high note?
Sure. I'm going to live band karaoke tonight. I haven't been in a month, so I'm going to go sing my heart out.
And you got your song pick. What song are you doing? These are the key questions.
I'm going to sing House of the Rising Sun tonight.
Okay. Yeah, if you come to New Orleans and you do the live band karaoke, and if you come to New Orleans on a night where it's going on, I'll take you. I know where it is. Don't do House of the Rising Sun. That's poor form in New Orleans. Elsewhere in the country, it's okay.
People come in like, oh, I'm going to do the song and say New Orleans. Everyone's going to love it. And everyone's just like, no.
Yeah, we're kind of sick of it, dude, honestly. It's a little overdone.
A Well, there's that, and I'm running a Spartan race in a few weeks, and that's about it going on in my life. Works good, and I hope you and your family are doing well.
Yeah, we are heading up. We'll be heading. It won't be interfering with our recording schedule, but we will be traveling next week, going up to the St. Louis area for a little bit to see family and hopefully swing by Holiday World. I've been hearing good things about that theme park. Everyone's telling me it's completely awesome, and my day will be magical and amazing in every way. So I can't wait.
So on behalf of myself, Evan Sherris, you can find me on Twitter at Evan Sherris.
Spelled like his name in the bottom
like
there.
That, Evan, E-V-A-N, Sherris, S-H-E-R-E-S. And you can reach me esherris@gmail.com, and that's all for me.
And I am Jonathan Bailey, getting back in frame. I'm from the site Plagiarism Today, which can be found at plagiarismtoday.com, and I'm username Plagiarism Today on all the fun things, Twitter, Facebook, etc., etc. Well, on that note, everyone, thank you very much for joining us. It's been great, Evan, getting caught back up. I'm glad we'll be back on our regular routine next week. So on that note, we will see you guys next week.